Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everybody, and welcome to our Spring Forward Legal Updates monthly webinar series. Today is our fourth of 2021 of our monthly webinars, and today we're going to discuss how to move from languishing to flourishing during COVID-19. My name is Lisa Stam, one of the lawyers at SpringLaw, and joining me today is my colleague, Emily Sue. Hi. If you are one of our clients, you already know that we are employment and contracts lawyers in Ontario at our virtual law firm. Everyone's virtual, I know, but we were virtual before the pandemic. Welcome to those of you who are new to our webinars. Today, we were going to go through some content, but it's also as much of a AMA as possible, so feel free to ask questions into the chat and we will get to them as much as we can. There's a handout tab, so feel free to pull that out. And finally, if you would like any more information about our law firm, just come to our website at springlaw.ca, where we have a variety of resources, including our weekly award-winning blog, our publication for COVID-19, a guide for employers that we keep up to date, a link to subscribe to our monthly newsletter, information about our innovative subscription program, and our ebook for employees who've been recently terminated and are looking for an alternative to in-person legal services. Here's our legal disclaimer, which we don't like any more than any of you sitting there having to take a quick look at it. But here's our friendly, lawyerly reminder that everything we share with you in our webinars is legal information, not legal advice that would be specific to your individual situation. So just give us a ring if you do have something specific that you'd like to talk to us about. Okay, our presentation today, we have three main topics: stress leaves versus low productivity and morale, and I'm going to talk about that. And then I'm going to hand it over to Emily, who's going to talk about the next two sections, the latest on sick leave benefits, and we've been getting a lot of questions about vaccines and testing, so we'll talk about the mandatory vaccine requirements. So in between all of this of sorting through how we move from languishing to flourishing, we will also give you some of the nuts and bolts about what the latest legislation and legal requirements are as well. Hopefully that's all helpful. So the first section, stress leaves versus low productivity and morale. I see some people still popping in. We have a lot of attendees today. So if you're just popping in now, we're only just digging in. So you're good to go. Okay, stress leave versus low productivity. So I don't know if you saw the article that was in the New York Times last month. They put out this great piece about languishing, which, if you're on social media, you definitely would have seen it floating around for a while. We all had to look up what the word languishing meant in this context and figure it out. But it really caught my attention because it's captured this in-between space that so many people seem to be in. We're not necessarily in a mental health crisis, but not really feeling joyful either. So there's something in between. So the way the author worded it in this article, and there's the link if you want to take a look at it, languishing is the neglected middle child of mental health. It's the void between depression and flourishing. It's the absence of well-being. You don't have symptoms of mental illness, but you're not the picture of mental health either. You're not functioning at full capacity. Languishing dulls your motivation, disrupts your ability and focus, and triples the odds that you'll cut back on work. It appears to be more common than major depression, and in some ways, it may be a bigger risk factor for mental illness. So apply all of that to a workplace and everything around your employees, and just we've been in this pandemic for a very long time. It it's, you know, everyone's burnt out, and let's not even talk about anyone who's on the front lines with the whole health crisis. Though, you know, anytime you talk to a healthcare professional in any capacity, they're wiped. They're very wiped. Today, we want to tackle the issue head on and share both legal and strategic comments about moving, and what are some of the things as a workplace to do to move from languishing to flourishing. So there are a couple of key impacts that we're seeing on the workplace, and these are just some of the anecdotal situations that we've really seen an uptake of. We've seen a lot more harassment complaints. We represent both, you know, the person who's being alleged to have harassed, and then, you know, employers who are dealing with a complaint that's come in because of harassment. Decreased productivity and overall morale. You know, we're talking to clients that are just sort of trying to keep things moving in their workplace, and dealing with shortage, you know, labor shortage all the time, people needing leaves, school in, then school out. You know, parents with young children are burnt out and stretched beyond capacity. So this decreased productivity piece is an issue. And then when formal complaints do arise, it triggers these investigations that are really disruptive and costly to workplaces. So what's interesting is that we're not really seeing a ton of big mass reductions. Last year, April and May, we did see quite a bit, but now we sort of prepped ourselves for, you know, looking at a year full of terminations, you know, like back in 2008 and 9, but that hasn't really happened. What we're seeing is distressed workplaces as we all kind of hobble to the finish line of this pandemic. So it's been, this languishing article really caught my attention because of what we're seeing in workplaces across all industries. So what does this all look like from a legal perspective? There are two main buckets that all of these issues fall into: OSHA harassment cases, and then human right disability accommodation issues. Now, there are all these specific COVID-19 related leaves and benefits, which Emily will speak to next. For the first bucket around occupational health and safety, the employer does have a proactive duty to investigate complaints of harassment, of workplace harassment and violence. And this can be the form of all kinds of different types of harassment. It can be called different things. Is it a toxic workplace? Is it a poisoned workplace? It's all the same thing. It's all workplace harassment. It typically will trigger an investigation, whether you do one internally or whether you pull in an external one. Either way, it's highly disruptive and very costly, and lots of diverted time and fees. The accommodation piece, the same thing. Every employer has a proactive duty to accommodate a disability up to undue hardship. You know, we're seeing a lot more requests for stress leaves that do require accommodation. You know, as soon as an employee gives you a doctor's note, you're kind of on the hook. You've got a deal. Undue hardship is a really high threshold to meet, as everyone knows if we've chatted with you about this. And in most cases, the employer is required to give the leave. So it kind of is what it is. Then the remaining employees are now stretched even further. There are jobs that still have to get done. And then, you know, with school, with summer coming and school out for a couple of months this summer, you know, it'll be interesting to see as your employees who are workers with young children. It'll be interesting to see how this all works out. Let's hope that the vaccines all get widely disseminated, and, you know, all the numbers keep coming down. But I you know, these two areas are the key issues where I think, you know, an employer really needs to be focusing to deal with what we're observing in the workplace right now. So what are your options? You know, for some employers, let's just muscle through, hope for the best. We're almost there. I don't think that's necessarily the best approach. I think proactively investing and moving from languishing to flourishing. Don't wait for the stress leaves and harassment complaints. Dig in now and try and proactively deal with this. Now, this is more of an HR than a legal issue, but it's all intertwined and one leads to the other. So talk to your team, more one-on-ones, understand where people are at emotionally, in addition to just simply making sure they're getting their job description tasks done. And then the other thing to check in on, the last year, so much of our economy and so many workplaces have really evolved and moved and pivoted. And it's good to check in and make sure the roles that your employees have, are they still, has it evolved in a way that reflects their current situation as opposed to a pre-pandemic job description? Are there additional tasks or responsibilities that have crept up into their plate, as a result of the pandemic or otherwise? We've been in this crisis mode for so long. It's as owners, as employers, as HR managers, it's good to step back and check in, because it's not sustainable to be in this crisis mode constantly, and see if some more retooling or redefining roles needs to happen. From an employment law perspective, that may mean doing, refreshing some job descriptions, moving things around, but keeping an eye on the stress leave piece of it all is a really critical piece to all this. If there's any questions about this, feel free to pop it in the chat and we'll deal with it. But I'm going to hand it over. In the meanwhile, I'm going to hand it over to Emily to take the lead on the next few slides around sick leave benefits.
Thank you, Lisa. So just as an overview, I'm going to provide you with a bit of background on a few options for leaves during COVID. So the first option, next slide, please, Lisa.
Sorry, thank you. We talked about how whether multitasking is a good idea. I'm like, I can handle the chat and the slides, don't worry. But I was just trying to do both of those things at once. So you have to ping me sometimes, Emily.
I will do that. Thank you, Lisa. Okay. So Ontario has a COVID-19 worker income protection benefit, which we will be referring to as a paid infectious disease emergency leave, so the paid IDEL. On April 29th, the Ontario government made updates to the infectious disease emergency leave, IDEL, which was formerly unpaid, and it also amended the Employment Standards Act, and introduced the COVID-19 worker income protection benefit, so the paid IDEL. So in addition to this unpaid IDEL, employers are also now required to provide eligible employees with this new paid IDEL, which more specifically requires them to pay employees up to $200 a day for up to 3 days for reasons that are related to COVID-19. And the 3 days need not be taken consecutively. So I'm sure some of you already know this, just to give you some more information. So who is eligible and how does this affect employees? So only those employees who are covered under the Employment Standards Act are eligible for this paid IDEL, this paid leave. Federally regulated employers or independent contractors are not entitled, but that's not to say they aren't eligible for other income support benefits. They may, for instance, qualify for the Canada Recovery Sickness Benefit, which is available until September 25th, as of right now. So in terms of what reasons related to COVID-19 means, and paid IDEL is available for these reasons, and that includes things like going to get vaccinated, going to get a COVID test, staying at home awaiting the results of this test, being sick with COVID, experiencing a side effect from the COVID vaccination, and having been advised to self-isolate due to COVID-19 by an employer, a medical practitioner, or another specified authority, and also providing care or support to certain relatives for these COVID-19 related reasons. So in terms of employers, they can be reimbursed up to $200 per employee for each day that's taken, but applications have to be made to the Workplace Safety and Insurance Board within 120 days of the date that the employer pays the employee. But in terms of how to apply, the provincial government hasn't given that much information, but it says that it will soon provide more information in terms of this. So when is this applicable? This leave is retroactive from April 19th. So in other words, if an employee took an unpaid IDEL from April 19th to April 28th, for example, or to now for a reason that would qualify them to take this kind of paid leave, then the employee can choose to take those days as paid leave. But I mean, this is a little bit, this is past the deadline, but as the idea is that the employee is supposed to advise the employer of this decision in writing by May 12, which has already passed, but that's not to say that this isn't something that employers can still accept, because it seems to be a reasonable request. So moving on to vacation time. Lisa, could you please? Thank you. So this is another option for employers who are dealing with employees who want to take a leave, or employers who want their employees to take a leave. When it comes to scheduling, employers have the right to schedule vacations and can require employees to take vacation when it suits the employer's needs. So if you have employees that are sitting on a bunch of unused vacation days, and you can actually require them to take that time now. If you offer paid sick time, you can also require that employees use up this time. A lot of employees, have in the past seen their peers being laid off, although it may not be so much the case now, but it still is happening. And so as a result, they may be more agreeable to this quote unquote forced paid time off. So moving on to some issues, some questions that are pretty common when it comes to leaves. The first of which is, what if an existing contract that an employee has already entitles this employee to take a sick or to take a paid leave for reasons that are related to COVID-19, the reasons that I've just spelled out? The answer is that if this is the case before April or on April 19th, then the employee's right to the 3 paid days under the Employment Standards Act will be reduced by the contract, so long as the amount of pay that's stipulated in the contract is either equal to or greater than the employee's Employment Standards Act entitlements. So that's something to keep in mind if the employee already has a contract that addresses leave for COVID-19 related reasons. Another common question that a lot of employers are asking right now is what happens if an employee has leave days and they've already taken all of their leaves, all the time off? Do they still get this paid infectious disease emergency leave? And the answer is kind of unclear right now. There's a bit of disagreement. Some firms are saying yes, others are saying no. And at this point, it's untested, so it's all theoretical analysis. And we'll have probably more information on what the courts say later on. But if we look at the purpose of the leave and the timing of it, we see that it's being rolled out around the same time that many people are getting vaccinated. So the government is anticipating, it seems like, that people need time off for the vaccine and time to recuperate from any side effects of the vaccine. So it's likely that even if an employee has, even an employee that has already used a paid sick days prior to the rollout of this leave are still entitled to this leave. And just even looking at this from a bigger picture business strategy, employers get reimbursed. So it's less of a strain on resources. And in addition to that, even if, as an employer, you want to refuse this additional paid IDEL, you can ask yourself the question of what if an employee, because they aren't able to take time off, ends up not getting vaccinated and then contracts COVID and then spreads it to everyone at work. And that would probably produce an even greater strain on the business. So business-wise, it can be a good move to provide workers with this leave, even though there isn't certainty on whether or not workers who have taken this leave already, taken a leave already, are still entitled to this.
Yeah, Emily, there was a few questions that came in, and it's specifically about this issue. So it's definitely a pain point for all workplaces right now. So I'll just, to make sure we fully answered these questions, here's one of the questions. Sick leave law in Ontario. So it seems the government funding is not available if you have already paid sick leave provided for those days. Can you clarify? Employers who already provided sick leave seem to be at a disadvantage as they won't get funding. Is that the case, or do they still, you can apply to get the funding even if you've already provided the sick days, can't you?
Yeah, I'm not aware of that restriction. My understanding is that right now the application process isn't certain, but the government will provide more information about that. haven't seen anything that restricts employers from being able to be reimbursed by this, get funding for this if those sick leave days have already been provided. It doesn't seem to, I mean, logically speaking, it doesn't seem to really work, because these reasons are supposed to be, the COVID-19 reasons are kind of tied to the vaccination. So, you know, if those sick leave days have already been provided and they're not for vaccinations, then it may not be the case that, it may be the case that the government will still provide funding.
Yeah, I think the real pain point is if employers have already, if you have a generous contract in place where people get 7, 10 sick, usually it's not that high, but there's 7 sick days a year, which is on the high end from what I see in most workplaces, and they've already taken it for, even if it's for COVID reasons or otherwise, and now are they going to get the extra 3 days? And I can see employers feeling very uncomfortable with having to provide yet another set of paid days. Now, as you said, Emily, they're getting reimbursed, so it's not straight out of the coffers, but it is people off work, not producing in the workplace, not moving things forward. So we certainly appreciate that there's a business cost there one way or the other. It's $200 a day, so depending on your employee as well, it may not even cover the full cost of someone being off. So there might be some math there that may not line up exactly. But I think on a technical reading of the legislation, an employer can probably maybe take the position that this is not in addition to paid sick days. This is if we didn't have sick days, this is what you would get. But I very much on the side of Emily, where even if you wanted to take that really strict position and prevent your, or deny an employee from the additional paid sick leave days because they've already received it, there's a business cost benefit analysis to happen here. And like Emily said, if something happens in your workplace, there's a due diligence problem for you as an employer, that you were unhelpful around people dealing with this highly contagious matter of COVID. This is not just the regular flu or the cold. This is something very specific to a highly contagious infectious disease. So I would caution employers to not be what is it saying, penny wise and pound foolish, and to really think of that big picture and the purpose of these days. Sorry, there's one more question here, and I know you have a whole bunch in the next section. When filing for a reimbursement with WSIB, does the money go back to the employer, count as a claims cost against us? My answer is that I have no clue. This is all so new. I doubt the government has figured that out yet. So I'm afraid I'm just going to say right now that we don't have the answer to that. It's do you have the answer, Emily? I'm assuming that it's.
Yeah, I don't think the government has provided that information yet. I don't even know if they know the answer, but I'm sure that this will become clear in the days to come, the weeks to come, probably. And there is still there's a 120-day time period for seeking reimbursement. So I'm sure within that period, the government will say something.
There's an interesting comment here that the WSIB told a colleague that employers who already provide sick leave will not be eligible for reimbursement under paid idle. So we'll have to, that's interesting. That's not government policy necessarily, because WSIB is arm's length, but it's sort of arm's length, not quite arm's length, but it's that if that's the case, this is the reality that we've all been living in for the last year plus now, is that the rules change every day. And so, that's a really interesting piece of information that I'm learning live in front of a whole bunch of people. So we'll bake that into our advice if that ends up being a position that WSIB takes, which isn't in the legislation at this point. So we'll have to see how they deal with that. Okay, and then yes, please, Jessica, who's our producer behind the scenes here, can you please share the link to Paid iDeal for all the attendees? That'd be very handy. Okay, there's a whole whack of questions here, but I'm going to jump ahead and let you, Emily, keep on going about vaccines in the workplace. This is another hot issue that we're getting a lot of questions about.
Thanks, Lisa. That's right. So this is a big issue right now, and there are a lot of questions around that. I'm going to start off by talking about vaccine requirements and whether this is mandatory. And the question of mandatory vaccination policies is, at least as of right now, it's not yet as much of a practical challenge because vaccines are still limited, but this may not be the case soon. And for the most part, it would seem that voluntary vaccinations might address this issue when we do get there, because most people do want to get vaccinated. But it may be the case that that isn't, that some employees don't want to. And so what happens when we get to that stage? In terms of the law, there is legislation, there's public health legislation that gives the government power to impose vaccination in Canada. So for example, Quebec's Public Health Act empowers the government to order compulsory vaccination of the entire population for contagious diseases that seriously threaten the health of the population. But that's Quebec specific. There aren't cases on mandatory COVID policies, but there is a case on mandatory testing, which is called the Crescent Care Nursing and Retirement Homes and Christian Labour Association of Canada, which is a 2020 case. And in this matter, mandatory nasal swab testing was upheld. The arbitrator in this case weighed the intrusiveness of the test. So on the one hand, you have a swab up your nose every 14 days, and this was weighed against the problem to be addressed, which was preventing the spread of COVID in the nursing/retirement home. And the arbitrator found that this nasal swab testing was reasonable. We might also look at, just in terms of precedents, mandatory flu vaccination during outbreaks. And there have been a few cases, and in some, the policies to get flu vaccines were upheld, in others, they were not. So we do see inconsistent results on mandatory vaccinations. So what happens then? Well, the adjudicator in any event will be looking at whether a policy or rule is reasonable in the circumstances of the case. That's something that is generally the rule for a lot of things, and I think in this case that will definitely be a consideration. They may ask questions such as, are there exemptions, accommodations? Do you deal with a highly vulnerable population or provide an essential service? Is there evidence to suggest that masking will not be sufficient to protect against the spread of the virus? Is there an inability to social distance or have other social safety protocols in place? And are there policies that require visitors to be vaccinated? And the degree to which an employer can require an employee to be vaccinated will likely depend on industries, on the specific industry. In some, it may be reasonable, in others, it may not be, but the employer will want to inquire as to why an employee doesn't want to get vaccinated before jumping to conclusions. And it's also important for employers not to discriminate against employees who have a legitimate human rights reason for not getting vaccinated. So if it's contrary to their religion or goes against medical advice, then these workers should be accommodated up to the point of undue hardship. And one thing I wanted to note is that the Human Rights Tribunal of Ontario has noted that something like mere political opinion, so believing that the efficacy of masks has not been sufficiently proven, has been held to not engage the protected ground of creed. So it's at least within the meaning of the code. So that isn't something that will be protected. I can move on now. I think I am keeping an eye on time, and it seems like we don't have much time left, but we can just talk briefly about some other notes regarding vaccines. So with rapid antigen testing, that is an option for employers, businesses with 150 employees or less. And this is a COVID-19 rapid screening initiative. And this is to identify individuals who are asymptomatic or pre-symptomatic to prevent them from spreading the virus in the workplace, at home, and in the community. And this is kind of a program just to keep workplaces, for the most part, safe while we wait for the vaccinations to roll out. And another thing I wanted to note was record keeping. A lot of people are asking about whether their employees are vaccinated, and there's a lot of discussion on that in workplaces, both remote workplaces as well as outside of remote workplaces. But at the end of the day, employers must ensure compliance with any applicable legislation that's related to the collection of personal health information, including the Personal Health Information Protection Act. So you want to make sure that as an employer, you're providing notice when you're collecting information and if you're using it and disclosing it. And you want to, we recommend that you seek express written consent and disclose information related to health or vaccinations only on a need-to-know basis, and that this information is stored in a secure file with restricted access, and that in terms of retaining this information, you can retain it until the end of the employee's employment or when the purposes of the collection are no longer served, whichever comes earlier, and also to protect the anonymity of employees who have not been vaccinated. So keeping cognizant of the time, I'm going to turn it over to Lisa for some final takeaways.
It is 11, and just if anyone has to hop off, obviously that's great, and we'll be uploading the webinar onto our YouTube channel, so you can certainly get a recording of it after the fact. So takeaways. I'm aware that there's quite a few questions that are still lingering around the sick leave days, and so I'm you know, if you do have questions, you know, reach out to us after. There's way more questions than answers at this point. It's relatively new. It was sort of a surprise rollout of a law that the provincial government rolled out without a lot of advanced warning to many stakeholders. So there's still a lot of questions to be answered, but we will do our best to help out. Takeaways. Number one, don't wait for COVID to be over and for everything to get back to normal. That ain't going to happen, and we are in the new normal, and COVID will be calmed down soon, I hope. Our numbers are going down. The vaccines are now rolling out. I was able to make an appointment for my 12-year-old daughter this weekend. I'm super excited about that for a vaccine. You know, it's happening, that it's, you know, that we're seeing some light at the end of the tunnel. So, you know, our new normal is almost here. The idle and the paid sick leave, we need to continue to sync that up with existing employee entitlements, all with the backdrop of potential OSHA complaints around harassment and stress leaves, and stress leaves in the context of human rights code issues and accommodations. So it's a big intersection, and sometimes just looks like a great big hot mess. But if it's pulled out and you can, you know, figure out what is the legal bucket that we're now focused on and sync that up with the HR bucket that needs to apply to it, you know, we're happy to help you sort through that in a sequential sort of way. And I think that comes to the end. If you have any questions, especially on the sick leave, I know that there's still a lot to sort out. There was a few questions about when will WSIB reimburse. It's just not known yet. So I know there are a lot of questions that we don't have the answers yet, and the answers just aren't available yet. So we will keep an eye on our COVID guide for employers. We roll that out regularly. We email people regularly about that, sign up to our newsletter, and then, you know, as a way to keep up to date. So we will try and keep people up to date on that as much as possible. That concludes our today's Spring Forward legal update. We hope you can join us on our next webinar, June 16 at 10:30 a.m. Details and a registration link will be posted on our website. Feel free to follow up directly with any of the lawyers here listed to, if you have any questions about that sick leave or anything else, come to our website at springlaw.ca, follow us on social on all our different channels, and check out our monthly newsletter. Thanks very much for joining us today.
Thank you, everyone.